Sam Seder on the Majority Report. Emma Vigeland off today. I want to welcome back to the program Matt Bruenig. He's the founders of the People's Policy Project, author of the NLRB Edge newsletter, and co-host of the Bruenigs podcast. Matt, welcome back to the program.
Oh, thanks for having me back.
So I'm a little bit familiar with this Louder for Crowder show. It is hosted by a guy named Steven Crowder. And about, I don't know what it was, like 2 weeks ago, maybe it was, I saw this video. I watched it. It was 45 minutes long. And it was an former employee of Steven Crowder's, guy named Jared, who they used to refer to on the show as Not Gay Jared. And he had been quiet for a couple of years. And there was always this sort of like these like rumor, like what happened to him? Why won't he say anything? And he just laid it all out. Walk us through what this guy has gone through for the past 2 years. I mean, I honestly, the only thing worse than working for Steven Crowder feels like to not be working for him anymore.
Yeah, I mean, in the last 2 years, especially, it seems like, Mr. Crowder was engaged in a divorce. I'm sure you've covered that extensively. And
I've heard rumors.
You've heard, yeah, there was a video. I don't know if you saw a Ring video.
I
did. And he, yeah, Mr. Monroe is my client, and, Not Gay Jared, as you refer to him. He knows Hillary, who is Steven's ex-wife, and, they're friends. And as a result of all this, Steven Crowder seems to have been really upset by Mr. Monroe just kind of being friendly with Hillary, and has pursued a sort of retaliatory legal actions against Jared.
And we should say, like, from what I understood from the video, Jared left because he felt this situation there was really abusive. And it took some, I mean, it took a decent amount of courage, because this guy was expecting a newborn with his wife. And to leave that situation's got to be a little bit nerve-wracking, to go out and not have a job in that instance. So can you outline like what happened once he left there?
That's an interesting question. He outlines it in his video. I should say he did leave with his brother, who also worked there. So, this was a widespread concern that was not just, specific to him about the workplace conditions. He subsequently was employed by CRTV, which is now The Blaze. And Mr. Steve Louder with Crowder sent a cease and desist letter to Jared about that employment, alleging that he had breached a variety of clauses. And, this was never litigated, but you get letters like this and it can become a problem, including for the employer that you now work for, because they are worried about getting sued for tortious interference with contractual relations. And so it just created, a lot of problems, a lot of legal harassment, even going back many years, not just the last couple years.
Isn't when he sends this letter, when Crowder sends this, isn't he also engaged, arguably, in tortious interference in this new employment contract situation?
Conceivably. But you know how it works with law, depends on how much money you have, who's willing to fight, et cetera, right? So the power imbalance with any employer, especially one who has as much money as Steven Crowder has, it just puts you on the back foot in ways that even if you are in the right legally, it's very hard to defend yourself.
Do we have a clip of Steven Crowder? When do we have that clip that I had asked for? Yes, I believe so. It's about the NDA. Yes. Do we have the NDA one? Can we play it? Okay, because I just want to ask you about this, because one of the issues in the unfair labor practice charge that you filed with the National Labor Relations Board is around a confidentiality rule, like I guess a so-called a non-disclosure agreement. And it's not the first time I heard about these, but one of the most prominent times I heard about it was actually from Steven Crowder complaining about the existence of it. Wait, all right. Well, we don't have that video. Okay. So, but that's where I heard him talk about this with the Daily Wire. He thought that was like an impingement on his First Amendment rights. So, which is odd. But give us walk us through this. Like what the things that you filed with the National Labor Relations Board are about, because it's not just about the working conditions that he was subjected to, but it's the implications of the contract, right?
Yeah. So when he left Louder with Crowder LLC, he signed a separation agreement that included a non-disparagement provision, which is a very broadly worded clause that basically says don't ever say anything negative about Steven Crowder, and a confidentiality provision which forbid him from disclosing the contents of this agreement. And we filed the lawsuit that Steven Crowder filed against Jared alleged that he breached this non-disparagement provision by potentially saying negative things to Hillary Crowder in the divorce context. But we filed a charge at the National Labor Relations Board where we allege that the confidentiality and non-disparagement provision are illegal under the National Labor Relations Act, and therefore must be rescinded from the agreement. And of course, if they're rescinded from the agreement, that would moot the lawsuit.
And so, I mean, when you say that they're illegal, are they illegal in this context? Are they broadly illegal? I mean, what is the, why can't two individuals just decide in a free country, even if one of them has like the power to harass somebody else for years and scare them that they're going to have no money for their family? Well, why can't two people or two, an entity and an individual enter into an agreement like that?
Yeah. So last year, the NLRB decided this case called McLaren Mome, and it's a almost exact same facts, a severance agreement that contain these two clauses, and they found that those clauses are illegal and unenforceable. The reason why that's the case is that you have a right under the National Labor Relations Act to, in concert with other employees, including former employees, to criticize the working conditions of your employer. And the clause read on its face would make that a violation of the agreement. And so if you have a clause that restricts your rights under the NLRA, that clause is not enforceable. And this kind of goes back to the very beginning of the NLRA. One of the big things it was trying to do was make it so that yellow dog contracts, which are these agreements where employees promise they will never join a union, to make those illegal. So this is kind of really core to the NLRA to say you have certain labor rights that cannot be waived, cannot be contracted away.
So if I understand you, it is irrelevant as to whether your client supposedly broke various provisions. Like, for instance, if he wasn't saying anything about disparaging him about working conditions, let's say he was just disparaging him like, I've changed my politics and I hate his politics, or this guy is hypocritical offset or something like that. That would be a violation of his contract. But before you even get to that assessment, the clause itself is illegal because it's too broad, and therefore the whole thing is struck down. There's no, like, you can't go in and sever different parts of that clause. Is that it?
Right. The remedy is to rescind the clause in its entirety. That's what they did in McLaren Mome. There's a case right now against SpaceX where they're pursuing the exact same thing. There is potentially two unfair labor practices that can occur when you have a clause like this. The first is just the clause itself. What they'll say is maintaining the clause. Maintaining the existence of the clause is an unfair labor practice because it would coerce someone away from engaging in protected activity lest they get sued, right? The second thing is enforcing the clause against protected activity would be a violation. So that is, if you did disparage by talking about working conditions and it was enforced against that, that would be a separate unfair labor practice. If it was enforced against some other thing that wasn't protected activity, that would not be a separate unfair labor practice. But the clause itself would still be an unfair labor practice, would get rescinded, and that would essentially moot your ability to enforce it.
So hypothetically, if I had worked for Crowder and I had signed one of these things, there's an unfair labor practice because it's so broad. But if he and if I had gone on to say like the working conditions were horrible and he tried to enforce against me, that would be a problem. But if I said, oh, and incidentally, this guy on weekends, he goes to bathhouses and it's very weird what he does there. That wouldn't be a unfair labor practice for them to go after me. But the initial underlying clause was inappropriate. If the initial underlying NDA was more narrowly tailored, in other words, like you can disparage our working conditions all you want. It's been reported that there's been all sorts of like weird, they put testicles on people's shoulders, which we stopped doing around here ages ago. But if the clause was you cannot speak to anything that Stephen or Bill or whoever worked here do after work hours, that would have been okay, right? I mean, that in and of itself.
Exactly. Yeah. Yeah. If you would have written a clause that says, you may not disparage the employer, except that you can discuss working conditions and whatever, right? Then something narrowly tailored like that would be legal under the NLRA, but that's not how this one was written.
Got you. And it is, so that's the same for both the disparagement and the confidentiality. You know what does not surprise me, Matt? That Louder with Crowder's attorneys are not familiar with labor law.
Yeah, I have learned a little bit about someone called the Half Asian Lawyer, who I believe drafted this. He's apparently a character on the show.
Interesting.
Yeah, that's not a character.
Interesting. I have not. I'm going to cop to not having watched the show that much that I know the entire
since the Rumble switch.
Yeah, exactly. Since Rumble, I am not medium agnostic.
You're behind.
I'm behind.
Catch up.
Yeah, my Rumble app is very buggy. It's. Then you have, it's maintaining an illegal confidentiality rule in an employment agreement, maintaining an illegal confidentiality rule in a separation agreement. So these are both those things that the clauses are overly broad and they are on their face unfair labor practices because of the broadness. Maintaining an illegal non-disparagement rule in the separation agreement, same sort of dynamic. Then your fourth unfair labor practice filed, engaging in unlawful interrogation and surveillance by seeking to obtain information about protected activity using the tools of judicial discovery. So they're basically weaponizing their lawsuit to find out stuff about like what Jared has been doing, like just who he's talking to, what friends of his he's talking to.
Yeah, so you have a right to talk with coworkers and former coworkers about working conditions, things like that. And you have a right to do that confidentiality without the boss being able to ask you about it or know anything about it. You can do it in secret. And if a boss in your workplace comes up to you and interrogates you and says, hey, I need you to tell me, what did you say to such and such? Where were you at this union meeting? Whatever, that's an unfair labor practice. And sort of by that same logic, using discovery requests where you try to depose someone or get documents about that kind of activity is the same thing. And there are cases, there was actually a case that came out just today about an unlawful deposition request that was directly sort of on point with this. So that's the idea there, is that when they have tried to get discovery in this case, those discovery requests were unfair labor practices.
So Louder with Crowder and his representation, the Asian lawyer, it's
the half Asian
lawyer. Very interesting who gets labels there. It strikes me as interesting. I know it has nothing to do with your case. It's just interesting. And they seem to be very nervous at the prospect of your client talking to current employees who may have similar issues with employment practices there that your client did in the first place.
That's right. Yeah, I suspect they're trying to get information on other employees so that they could try to bring similar claims, but they probably are unaware of the National Labor Relations Act, and in just literally writing that in a court document is not a good call. You don't want to say, we want to ask Jared questions about his conversations with former and current employees. That's the worst thing you want to put in a filing like that, and they have. So.
Wow. Yeah. Cause that basically gives up the game. Like, like a cleverer attorney would be like, we just want to generally ask him broad questions about stuff and stumble into that. But when you're literally saying we want to violate the National Labor Relations Act, and that's why we want to ask these questions.
Yeah. In writing, like normally the way it'll work is they'll get the deposition and then you'll have to go through the deposition transcript and identify the questions where they're violating. Here, they've just declared in advance, we're going to ask violating questions.
Well, that makes your job a little bit easier, I would imagine. You don't have to go through each specific instance. Sending the fifth one is sending legal threats, instructing Jared not to engage in protected activity. That is having those conversations with friends, coworkers, former coworkers, etc. I would imagine.
Right.
Filing a baseless retaliatory lawsuit that seeks the illegal objective of enforcing illegal confidential. Okay, so this is just about the mechanism in which they're doing is in and of itself these type of like intimidating lawsuits in furtherance of an illegal clause in the contract itself is in and of itself an unfair labor practice.
Yes, a separate unfair labor practice. And that is a key one here because that is the one where you will get monetary remedies. If you file an illegal lawsuit that seeks an illegal objective, the damages there are the litigation expenses of the worker. So that's the one where they're going to pay our legal bills if it goes, the way I'm thinking it will.
Now, okay, so all of these activities here, and I have two sets of questions. One is, what about this is all sort of like, it seems to me, surrounding the actions that they took as an employer after the end of the employment, in addition to certain contract, the separation agreement and the employment agreement. These are unfair labor practice. But what about the actual practices in the workplace? Are there actions that could be taken based upon, and I'm just going by the reporting, and obviously these things would have to be substantiated, but allegedly there were situations where like you would get slapped with a sexual organ, during the writing sessions, which I'm unclear on the research as to whether that helps in writing sessions, but presumably not appropriate to do, and I would imagine in certain instances considered poor labor practices. Are there any actions that are available for the actual sort of first order issues in that workplace?
Yeah, some of those allegations, obviously, I don't know if they're true, but for instance, the one you're talking about, that would be sexual harassment, creating a hostile work environment. You could bring a Civil Rights Act claim against that. I don't think Jared was there for that, or at least he's never discussed things specifically to that. There could also be, he left 6 years ago. It might be too late. I'm not sure exactly when the timeline is on that. But the other thing that's worth noting here, as far as like other workers and current workers, is the remedy that the NLRB would provide here is they would order Crowder to get rid of these clauses in every agreement they have, not just Jared's. And it does seem like that could be an even bigger deal than, successfully fending off this lawsuit, just based on, there's just been reporting of other workers who've been who are subject to this.
So hypothetically speaking, in the event that all of these NDAs and non-disparagement clauses are out, and these other past and maybe even present employees realize that they're not at legal jeopardy for talking about these things, they might be more willing to go to an attorney and say, hey, I'm free to talk about this. Is this, do I have an action here? And those lawyers theoretically could say yes or no, or in other words, this could be like a cascading series of lawsuits. All right. And so are there any also, you mentioned that number 6 gets you, because of the lawsuit, it would bring, there would be, to make your client whole, they would be liable for all the legal fees associated. Are there any other tortious remedies associated with this? Like, if I'm just a tort lawyer, not looking at, and once you as have established in this case that there are unfair labor practices, can I come in as a tort lawyer and say, okay, you guys broke the law in pursuit of this. And my client is a mess now. Like, just hypothetically, like you could look at this video. This guy's a broken guy. He hasn't been able to work. He's been scared away from employment. He's probably employment, in this, realm are probably severely limited because I'm going to sue you guys for, I don't know what, like tortious interference in the contract, or I'm going to sue you for damages, or is there any actions available to your client or to these other clients that go beyond this rubric of unfair labor practices?
I'm not really sure. Like you said, tortious interference with contractual relations is a very generic tort that potentially is available. Not for the non-disparagement stuff, probably, but some of the stuff where it seems like they were working hard to make sure he couldn't be reemployed, stuff like that. If it's not time barred, but yeah, that's a little bit beyond what I do. So,
well, if there's any tort lawyers out there waiting in the wings, I can imagine after. Once this question is resolved as to whether they broke the National Labor Relations Act, then it seems to me like you have another pivot point for this stuff. But I don't know. I'm not an attorney myself, so I'm just this is maybe just wishful thinking on my part. But so what happens next? Like, how long of a process is this?
So we actually gave our sworn statement to the board this morning. And after that, they'll have an investigation into the company. The investigation should be pretty straightforward because the whole case is just provable by documents. We don't have to make credibility assessments, talk to a bunch of witnesses. The documents say what they say and the law is what it is. So the investigation should come pretty quickly. The only question is, what other cases do they have and how far back is it in the queue? I think last I saw, they were saying on average, these cases are taking about 100 days till you get to complaint. But that's just because of backlog at the agency. Right. So that's what we're, I guess, waiting for is complaint or settlement. Most of these cases settle. I don't know, like at some point they'll be confronted by the board agent with the fact that, hey, we're going to issue a complaint. You're almost certainly going to lose. What do you want to do? Most employers will settle, but Crowder, is an interesting personality. So who knows?
Yeah. And I would imagine there's there's added pressure. I would even, obviously that's not the intent. I'm curious about this case, but I would imagine even this level of publicity, everybody knows he's either going to settle or there's going to be a public, it's going to be clearly found wrong in the public. So people are going to know one way or another. And supposedly he's a fighter. That's one of his big things.
Yeah, I saw that when we got into it with that Teamster.
Yeah. Yeah. Well, sometimes the best, Muhammad Ali did the rope-a-dope. And so, that sometimes that might be the best move that you have in those instances. Now, there's no way whatsoever that you're ever going to depose Crowder, right?
If it goes to an administrative law judge hearing at the NLRB, he certainly would be brought in as witness. So that would be to testimony, not deposition. I would not be asking the questions. It would be the board agent in the case who would ask the questions. But if it got there, he would certainly be asked to speak.
This is the second time I've made this offer in a week, but you'd be in attendance. Would you need an intern working for you at that time?
I think you can come to these. I believe these are public hearings. No one ever does come to them. So, but
I need to take a flight.
I'm going to
imagine his voice if you were in the back of the room.
I'm going to rent a private jet. Fly wherever that goes. I will empty out my kids' college fund.
Take a selfie video like Jimmy Butler on the plane up to Boston.
Yes. All right. Anything else that we should know about this, do you think, Matt?
No, I mean, it's there's some irony here that, it is the NLRB. Obviously, a lot of the stuff is coming from the recent NLRB. I know you've covered that. They've been really aggressive to push the law on this stuff. So, if it were a different board, we probably wouldn't be able to do this. So, there's a political angle here as well.
Well, there was one thing actually, and I don't know, this may not be something that you can talk about, but when I was watching your client's video that sort of announced this situation, I think this before you were representing him, and he seemed to be like, I've just simply run out of options, and this is just the harassment's just too. I mean, he seemed really at the end of his rope. I mean, I generally don't feel a huge amount of sympathy for folks in that world, but I genuinely felt sympathetic. I mean, this guy seems to have gone through real hell in many respects. But as I'm watching it, it's occurring to me, it's like, dude, this is government has got your back on this. I mean, at least right now, you're going to be surprised at what the value of having a National Labor Relations Board is and what, labor law is. Like, I mean, he's talking about these NDAs and I'm going like, I think you got, it's not just bad form, it's illegal in many respects to have something this. Was he surprised, like when he found out that there was action? Like, I don't know how it is that you came to represent him in this instance, and maybe if you feel comfortable talking about it, I'd be very curious. But I mean, did he go like, oh, I didn't realize? I mean, clearly Louder with Crowder has no idea that these laws exist. Based upon what they basically handed, it's almost like you had to just fold up their documents and mail it off as part of the complaint. But did your client, how did you end up come to representing him? And was he like, oh, wow. Yeah,
I mean, so I'll just say, just to clear the throat here, he's for publicizing this. So, he's told me he wants to, get this out there. Obviously it's a public dispute. So normally I wouldn't just reveal this, but he's giving me the green light. But I saw, a bunch of people sent me his video. Obviously I file charges all the time on stuff. People know that. I also did a case recently for a very similar situation where people quit a radio station and started a podcast and were getting harassed similarly. And we won that case. So I got a lot of people saying, look at this guy, isn't this the stuff you do? And so I was like, yeah, this is a very straightforward case, it seems like. So I emailed him, and he told me he talked to his buddies, conservative friends, he knew a little bit about me, but not too much. And that they told him that he should definitely, take my call. And so, so then he got on, and he said he talked to some lawyers. There was one entertainment lawyer who kind of mentioned something about the NLRA, but, it's a niche area of law. Most of the people who do it represent unions, even though there are individual rights under the NLRA as well. And so it can be hard to run into someone who knows what to do. You know, it's not like filing a normal case. It's a unique niche area of law. So, yeah, I think he just needed to run into the right person. And then the irony is not lost on him, obviously, you know, with the labor rights and almost socialists and all that. So, but, you know, he's whatever else he's saying, look, I get like employers can be pretty abusive. So, you know, I guess that's severable from other conservative beliefs you may have.
It'll be interesting to see. I mean, you know, if there's an evolution in
It's a teachable moment.
yeah, I mean, an evolution in his broader thinking. I mean, I get it that you wouldn't necessarily run into lawyers, but like the overall notion of like, hey, this is a good place for government intervention in this relationship, because for a lot of like, I think, you know, I think they've gotten away from it a lot, but like, you know, the idea of like an unfettered freedom of contract where I can enter into any type of is almost like the bedrock of the conservative movement. I mean, a lot of them, I think, have it's gotten filled up with like Dr. Seuss and all sorts of like other things that, you know, but that's what the fundamental basics was.
It's funny because obviously the left is of the view that we need collective bargaining and unions and substantive labor market regulation in order to protect workers. The conservative alternative, to the extent that they offer one, is free markets and free speech, right? If you don't like your job, go get another one, tell other people, and that will kind of self-regulate the market. You can't be a bad boss because people will know you're a bad boss. No one will work for you. People will quit. And instead, we get these contractual arrangements which make that sort of conservative alternative actually impossible. The non-compete clauses make it so you can't leave. The non-disparagement and NDA make it so that you can't tell other workers, warn them. And so, you know, it's a kind of an experiment to see, do they really think that's the alternative, or do they really just want to kind of keep workers under control? And as soon as they have the opportunity to actually clamp down on freedom of movement and freedom of speech with respect to the employers, they are happy to put that in every single contract, you know, that comes their way.
Well, that's always been, I mean, I have an opinion on which one of those that is, but it's always been, that's always been like the loggerheads though, right? Is because like that attitude, which you express where, you know, if I don't like the employer, I can leave and I'm free to go on my own. And I can, you know, say like, they're a bad employer. Don't
Shop
work for them.
bosses.
Yeah, exactly. Like that's that sort of more libertarian perspective. But the real old school thing was the freedom of contract, which is there is no power disparity. I as an employee or you as an employer, and I, you know, nobody's got a gun to my head, and I don't have to work here. And so if I sign away this, you know, whatever it is, you get my firstborn boss, you know, after I'm too old to work. That's fine. I can do that. You know, obviously not literally that, but I can do that, and it's okay. Just the existence of a National Labor Relations Act is almost like an affront to that sensibility. But those two things clash, right? Like you know, the idea.
Yes. Yeah. The basic premise of the NLRA is that employment agreements are not really voluntary, which I mean, I 100% agree, right? But it is this weird wrinkle in an otherwise kind of freedom of contract type world we live in, where as long as two parties agree and sign on the dotted line, then consent is achieved. It's a mutually beneficial transaction, and all these assumptions go in. The NLRA kind of takes as its jumping off point that wherever, maybe that's true in some places, it's not true in the workplace. Workers don't have enough power to bargain with their boss, certainly not individually over specific things. They get these take it or leave it contracts, and you know, they will just sign away their rights because they need to work or they'll die.
And I would add too that the idea that the bosses enter into that relationship without the government in some way advantaging them, I think is also not the case. I mean, our society is set up in such a way. Government is picking winners and losers every day. And it's really less a question of like, the government deciding to just intervene on the side of workers. It's already intervened on the side of capital and management. Like,
of course, yes. I mean, even with corporate law and the whole structure, that's what makes the employer so much more powerful than the worker. Are these structures, whether they're securities law, corporate law, contract law, property law. So it becomes a question of how do you want to construct the overall system and make it all work together. And I agree with you. It's important not to naturalize the sort of general corporate structure and then view us as intervening there when the corporate structure itself is a government institution.
Exactly. Well, what are the chances that you can come back every day for the next 100 days to give us an update on it?
If you want updates, when they come, I'll email your producer whenever we have updates.
We will have you back on for every update that exists.
Just use the same link, Matt.
Yeah, exactly. You could, as long as we're not interviewing somebody else, just hop right on the stream and we will take that update. But Matt Bruenig, really appreciate your updating us on this and the work you're doing, and just it was very fun for me to hear about this. And I guess also, if there are folks out there who have gone through similar things like this, maybe they should contact you to
hit me up, Matthew Bruenig at gmail.com. I'm taking clients.
There you go. All right, Matt, thanks so much. I really appreciate it.